which is University of Tennessee Space Institute down near Tullahoma. There he brings home a gross of a little over $8,000 a month and a net of about $6,400, $6,417.55. He does get a military retirement of $4,001, of which he's got to pay her $1,739 of it. And we're not disputing that issue because based on the marriage, she's entitled half of what was done during the marriage, and that is a proper amount. His net is about $11,332 a month. His gross is considerably less. He has to pay taxes out of his, including the amount that he has to earn to pay her the
I'm sorry.
Yes, sir.
Did you confuse those two? I think you said his net was 11,000.
Oh, I apologize, sir. I said his net is 11,322.
That's his net?
His net, yes, sir. His gross would be considerably less because he has to pay taxes on his.
Okay, that's the pension plus his salary.
He has to pay taxes on his military.
But the net is his pension plus
Yes, sir.
salary, okay.
So he has, I'm not saying he's wealthy, but he has a comfortable standard of living. It's better than they ever had during their marriage. Because during the marriage, they had children, they basically one vacation a year, they struggled to make ends meet. So this is their situation. Wife gets her half of his military retirement of the $1,739. She also gets a Social Security disability check of $924. She has wealthy parents who historically have given her well over $10,000 a year. That was ignored by the court, but that continues to include buying her a house, buying her car, things along that line. She has an investment account of $48,000. She got a back due support payment from Social Security of about $30,000. So she has a lot of cash, plus she's resorted a lot more assets here. When this case began, I was not his attorney, but the wife came to court claiming a need of $5,137. That's what she said, that's what I need. That did not include her Social Security because she had not gotten that yet. That did not include the retirement account because she had not received that. So when she came to court, she initially claimed a need of about about $3,000 on top of what she already received. When we went to court, she came to court with the dream sheet. And I'm sure the court has seen those where you go to court and you ask for everything. She asked for everything. We're going to go through her needs shortly and how egregious they are. But when we came up to court, first thing you look at, what is her ability to work? No proof, none. No medical expert, no occupational therapy expert, no Social Security records, no reflection on what her medical issues are and the effects on her. She said, yes, I have thyroid cancer. Well, is it in remission? We don't know. She didn't testify to that. I had a hysterectomy. Well, what's that prognosis? No testimony. She just said, that's what I had. I had 4 joint repairs. I don't know if that was her finger, her neck, her knees, or her hips. She didn't say what joints. She also didn't say what limitations it has on her. She says, I had, past tense, fibromyalgia. I don't have any more. And I've had some other issues, anxiety. So based on that, the judge basically said, okay, you can't work. And that was the testimony on her ability to work. There was nothing there. No medical expert. I mean, it's one thing if you put in the Social Security records and they're stipulated to, and it shows that she has these limitations. But when she came to court, despite not being able to work, her dream sheet included over $150 a month for marijuana purchase. And the judge gave it to her. The judge gave her everything she asked for, plus more. You know, I've seen judges cut things down. No, she gave her everything plus more, which included over $150 a month for marijuana. She needed, according to her, $200 a month for alcohol every month. She's having a heck of a nice time while she can't work. She says, I need $850 for rent because she's living in her house that was paid for by her parents. Never paid them a dime. But the judge gave her the $850 on the, I guess, on the premise that she might pay her parents in the future, but she never has. She needs over $500 a month for an automobile payment for a car that was paid for by her parents, given to her, and she never made a payment on. She says, I need $2,000 a year for furniture. Don't, just because I'm gonna need to replace it every time, so I'm gonna have $2,000 a month. $150 a month for cigarettes for habits she claims she's gonna stop. But she got that $150. She got every one of these things. Like I said, I've been to court before where the courts cut it down. No, gave her everything and gave her about $50 more on top of that. Says, I need to buy gifts for all of my children, all 5 of them, all of their spouses, 3 of them, all 8 grandchildren, my parents, my sisters, of at least $125 a month. Judge said, that's needed. Question, is that a need? I want to pay money to the church. That's a great thing to do. I don't have a problem with that personally, but that was a need that the judge gave her every dime of. I got to get my hair done every month, $60 a month. I'm not working, I can't work, but I'm going to get $60 a month for that, along with another $70 to get manicures and pedicures every month for a lady that can't work and has to, well, I'd say she stays at home, but we'll talk about that shortly. She doesn't stay at home. She needs to go to a therapist, so she goes, I get $75 a visit, 3 visits a month, and I'm only going 1 time. But she got 3 times a month, despite the fact she's only going 1 time a month. She wants to travel to see her children every other month. So this lady who cannot work can get in her car, drive from Florida to Virginia, to Tennessee, to Indiana, stay at hotels, take her kids and grandkids out for meals at all of these locations, and my client has to pay every dime of it. I want to, on top of that, even though I'm traveling every other month to see my grandchildren, I need another $150 a month just to go on vacations for a lady who's disabled and cannot work. We would respectfully submit that if you can drive those distances, if you can appear at court, you can testify, there is not one iota of testimony that says she has any limitations, that she doesn't get everything she wants. She wanted $80 a month for massages. She had past term fibromyalgia, doesn't have it anymore, but she wants to continue the massages because I guess they feel good. She wants a $200,000 life insurance policy to cover her funeral expenses. I guess we'd all hope to be invited to that funeral because $200,000 for a funeral is a lot. The court expert basically took it, the expert that they hired took everything that she wanted, didn't analyze it, didn't even ask her questions, just took it, ran with it, didn't even talk to my client and started cutting everything he had. We'd respectfully submit, when you look at income and need, she needs some money. I'm not going to say she doesn't deserve some alimony, but if you look at what she initially claimed and what she's wanting, she's more like $1,500 a month. Duration, the law is somewhat clear in that regard now, but if he was 30 years of age, we wouldn't request to be addressed, but based on his age, we'd like to say, if he hits full retirement age and retires, it can cease. So we don't have to prove that that's something out there. And finally, attorney's fees. She was awarded $20,000 for supposedly failing to answer discovery. Go through the record. There is no discovery. Go through the record of her timesheets. There are no timesheets. I want $20,000. She got $20,000. Wright v. Wright says we have to look at it. The burden is on them and analyze the time and the actual time spent, and we don't have anything. So we'd respectfully submit that should be set aside and the alimony reduced to more like $1,700 a month. Thank you, sir.
Well, thank you.
Good morning, Your Honors.
Morning.
Diane Crozier, I'm with the Williamson County Bar. I represent Ms. Van Zanbergen. I'll respond to Mr. Hornsby's statements. I want to say that at the trial, and I was trial counsel in this matter, Mr. Hornsby was not, but when we had the trial, the husband never submitted an income and expense statement at the trial. So he never put on any proof as to his inability to pay the alimony that was submitted by Ms. Van Zanbergen. When Mr. Hornsby's referring to her ask pendente late, that ask was different because Mr. Van Zanbergen, husband, was still paying some of the marital expenses. So her need at that time was different because he was responsible for some marital expenses that were status quo that he had to continue paying. At trial, she submitted a need of a little over $7,000, and the court awarded her $4,350. Now, I think we admitted in our brief that there was a little bit of an error there. In her worksheet, she had asked for $4,305 reflected as her need, and the trial court judge awarded $4,350. The judge went through all of the factors. Well, I take that back. Maybe not every numbered factor, but the important factors, the ones that the trial court determined in the memorandum, in the court's memorandum opinion, finding the conclusions of law and findings of fact. Those are all set forth in the court's opinion. Ms. Van Zanbergen testified that she was on disability. I submit that if husband wanted to contradict that, he could have hired an expert, that she didn't need an expert to prove she was on disability because that had already been determined a few years prior. Some of these expenses, I can address those. I don't know if the court wants me to address all of them, but the marijuana was medical marijuana because Ms. Van Zanbergen was a resident of Florida at the time. That was a legitimate expense that she had a prescription for, and she presented that.
Is she not a resident of Florida now?
Yes, she still is.
Okay.
Yes. The parties, of course, last lived in Tennessee together.
What was
As
the
far
proof
as-
about her ability to work?
What about, she testified as her physical limitations, her mental health limitations that she had, and I would just submit that the fact that she was on disability and that had been provided to her, that was proof enough, and that they didn't rebut that proof. Submit that the trial court has discretion in awarding the alimony. The judge addressed her need and, again, Mr. Van Zanbergen's ability to pay, but he didn't rebut. He provided no rebuttal to that at trial whatsoever. There was proof about his income.
In the trial, you had proof, or the trial court had proof concerning his income and what his net would be after taxes. Is that right?
Yes, sir.
And what was his net after taxes?
I think it was what Mr. Hornsby, if I can find that in my brief quickly, but I believe it was around the $11,000 mark.
I know his counsel is calling that his net, but that's actually his gross. What was his net after all of his taxes?
So, Your Honor, give me just a minute. Because he had rental income also. There was other income besides his income from his employment, his pension, and he has rental income from some inherited property as well. I know the judge referred to that in her opinion. And I'm sorry, I can't say that right off because there were several things that were factored into that as well. The court found it was a gross income of $8,000. Hold on just a minute, because I think she refers to his net. Had a gross income of $8,000, another $4,000 from his military pension, $117 a month in longevity pay, and $125 a month for some other allowance, and another $750 in rental income that he got from an inherited property.
But the military income, his amount is not $4,000.
No, sir.
Because out of that, half of it, well, almost half is paid to the wife. Is that right? So what I'm trying to ask you is, when you consider the deductions from taxes, from his wages at UT,
Yes, sir.
the balance of what he receives in military pay, what is that figure? You know?
I don't think I have that exact figure, Judge. Let me,
But it's not 11,000, is it?
no, sir, it's not 11,000 net. No,
Okay.
sir.
It's more like 9,000, isn't it?
it might be considering everything because the rental income is in there as well.
And then if he pays $43.50 a month in alimony, he's left with $5,000 a month, is that right?
Yes, sir. Yes, sir.
And then your client is receiving, with that award, including Social Security and military benefits, in excess of $7,000 a month, is that right?
Yes, sir. But I will say that I believe the numbers are about right. But I will say that at the trial, there was a lot of testimony about husband was living with his girlfriend and she was contributing to the expenses, and she said she was paying half of everything. So that factored in on his ability to pay as well.
Is there really any dispute that your client does not have a car payment and also does not have a mortgage payment or rent?
Yes,
Is that
sir.
true?
No, that's not true, Your Honor. Her parents were helping her while the divorce was pending because they had no choice. She was getting $2,500 a month, and that wouldn't pay all her expenses, and she hadn't gotten her disability at the time. So she testified in court that her parents would not continue to do that post-divorce, that they were only doing that to help her out in the interim. So there is a dispute to that, her testimony.
That was her testimony, not her parents' testimony.
Correct, her parents did not testify at trial. But they were deposed by opposing counsel, but they didn't testify. And with the award, she's able to pay her expenses, so that her parents wouldn't.
Yeah, what about these expenses? And I know you had an expert, and tell me, what was your expertise?
Her name is Rosemary Frank, Judge. She's a financial advisor and helps through divorces, helps women in divorces plan their expenses. And she has the exhibits and the trial exhibits, she has a very detailed way of going through expenses with the clients and taking their expenses and reducing them and trying to weed out unnecessary things in their expenses.
And is this person an accountant, a CPA?
Yes, sir. Yes, and she has several credentials just with financial planning as well.
Okay.
And she was stipulated too as an expert with opposing counsel at trial.
Okay.
If I can touch real briefly on the attorney fees, this divorce was pending over 2 years, a period of time. And Mr. Hornsby argued that the judge just awarded those fees based on failure to answer discovery. That's not true. The judge cited in her opinion that it was for that and other failures of the husband to comply with other court orders, such as he changed, as soon as the divorce was filed, he changed beneficiaries on accounts. He moved monies in violation of the restraining order. He tried to cancel her phone. There were several things that he did in violation of the restraining order that we had to file motions over. Ms. Van Zanbergen's fees for the 2 years that the trial was pending and the 2-day trial that we had to have were $77,000. The judge ordered her just $20,000 of those fees. Counsel argues that the invoices weren't, a detail of the invoices weren't submitted. The affidavit that was submitted is in compliance with the Rule 8. I have reviewed it over and over to see if I'm missing something saying that detailed invoices have to be included. I do not see that in the rule. Those were not included, but I can say that the husband never filed anything after the judge awarded those fees challenging the reasonableness of those fees. So if anything, I would say he's waived that argument at this point. I don't think I have any other issues I need to address unless your honors have any questions.
Don't see or hear any, so thank you.
Thank you, Judge.
Mr. Hornsby?
Yes, sir. Mr. Van Zanbergen's net after paying taxes is about $7,003 per month. You'd ask that question. We had the gross numbers about 11. You're right, he's gotta pay taxes, and he's gotta pay taxes on the over $4,000 he pays her because of the change the IRS has made. That's just what the law is, so that's not a problem. She's getting more than half of his income right off the bat, plus her Social Security, plus part of his military retirement. With respect to medical marijuana, go through the record. There is not one iota of proof that this was medical marijuana. There was not one iota of proof from a doctor. There was no testimony even by her that I was prescribed this by any doctor anywhere. Yes, she lived in Florida. That by itself doesn't mean it's required in medical necessity. And we respectfully submit there is nothing in the proof, not one prescription, nothing. She hid it under prescription, and only under cross did she come out with the fact, well, I got by marijuana. I've been using it for years, when she was living here in Tennessee, before she even moved down to Florida. With respect to the attorney's fees, for failing to answer the discovery, there's no discovery shown anywhere that he failed to answer. The testimony was he did the best he could. They acknowledged he answered something. And, you know, it's one thing to have a hearing, have testimony, have the exhibits, have the discovery submitted, what was asked, how he answered it, how he failed in that regard. But there is absolutely nothing on this discovery. And on the timesheets, I would respectfully submit, when you look at the Wright case, one of the items that you're supposed to look at is the amount and duration of time spent. Because you can go through that as a result and say, I disagree that it should have taken 3 hours to dictate a letter to me, for instance. And that would not happen because I wasn't the attorney at the time. But you can look at the timesheets and see if that time was reasonable in amount, was done on the proper time, and that's the problem we have in this case.
Was the reasonableness ever challenged at trial?
It was asked for, it was objected to, but there was no motion to alter amend to come back and challenge it. That is correct. Appeal was made, and I think that's, but the burden is not on us, the burden is on them to prove the reasonable and necessity of these attorney's fees. And I would respectfully submit, when you read the Wright opinion closely, which refers to the Supreme Court rule, what they did in the Wright case is they looked at all the time spent and they decided that some amounts were not reasonable and necessary. How can you do that when you say, I want $20,000? I want $70,000. I am not saying that Ms. Crozier did not do work, but was it reasonable and necessary on this amount and this amount? And we would respectfully submit that they failed in their burden in that regard. And alimony, when you leave a courtroom and you get less than half your money left over and she walks away with not double what you got but getting awful close, I have some concerns about that. And when you look at her needs, how egregious they are from the standpoint of marijuana that always continued, alcohol $200 a month, 6 trips to the family driving, and not one iota of proof that she couldn't work. She never said, I cannot work. I cannot sit for 3 hours. I cannot stand. I got these limitations. She just said, I had fibromyalgia, it's in remission. I had thyroid cancer. I had a hysterectomy. I had some joints fixed. I have some anxiety. Any one of those could be a basis for saying you're not able to work, but there was nothing, even that she said, not excluding no occupational expert, no medical testimony, nothing from Social Security, that she cannot work. If you can get in your car in Florida and drive all the way up here to Tennessee and up to Indiana and Virginia 6 times a year, plus take vacations, you might be able to work and help take care of your needs to some extent, as opposed to sitting around, getting your hair done, your nails done, and drinking every day.
Let me ask you.
Yes, sir.
You said she walked away with twice the amount of the husband. Are you talking about the division of the marital estate?
No, sir. I apologize. We're talking about income. As for the division of the marital estate, we are not challenging that. There's no table attached, and if I misspoke, I apologize.
But she didn't walk away with double the amount. That's what I'm
No, sir. She walked away with double the income at the end of the month.
Okay.
So when you figure out what he brings home at the end of the month, and then you tack in what she receives, plus her Social Security, plus her payments from her parents, plus investment income and everything else, she's close to double.
And looking at the record, when we find what your client claimed his needs were monthly,
Yes, sir. Even their expert went through and said his needs are over $5,000 a month. Their expert, who didn't ever talk to my client. They weeded his numbers down, but they said he needs over $5,000 a month.
okay, thank you.
Thank you. Thank you both. Would you call the next case, please?
Stephen Snyder et al. versus Second